I would not do any bond, zero bond, none bond, because unless it's forthwith within 48 hours, nobody should have their due process rights taken away because we can't get a criminal complaint filed forthwith.
I agree. It is unreasonable for people to be on a cash bond without seeing a court and no
Any
complaint.
bail bond conditions, any, because right now, this individual, if I have him on bail bond conditions, this individual, and he's not getting a complaint filed a month and 2 days after, why should he risk to have bail bond jump violations when he hasn't even been charged? He doesn't even know if he is going to be charged.
I agree.
So zero bail, zero bond, unless we have a criminal complaint filed forthwith within 48 hours. This is a 1 o'clock, but it is a GF. And this man and his wife just walked 2 hours to be here this morning. And I don't believe that we have anything filed, do we?
No.
You can have a seat, sir. We will go on the record in the matter 26 GF 133 group file of Brandon Campo. Appearances are we do have appearing in person the district attorney Kevin Schmidt. Mr. Campo appears in person without counsel. We are in victims' rights compliance because the victim is sitting right back there, Ms. Bauer. That is the victim. Look at her face. That is who she is. And so we have Mr. Campo here. This matter, he was brought before the court for the court to put him on a cash bond, a significant cash bond on May 26, 2026. There was enough there for the court to make a probable cause finding because the court does have at least a small police report in this matter. And so he's here. It was scheduled at 1 o'clock, but the man and his wife have walked 2 hours to get here. Correct, Mr. Campo?
That's correct.
You don't have a means of transportation?
No.
And so why are you here at 1 o'clock? Or why are you here now instead of 1 o'clock?
I was trying to get the court date changed because I don't have an attorney.
Because you don't have an attorney, but I understand that, but you don't even have charges filed against you. You understand that part?
So I didn't have to appear?
I would say probably no, because there's nothing filed, but you do have cash, $1,000 cash that was posted based upon a very lengthy probable cause statement with facts enough that you could have been charged or probably should have been charged by now, since it is June 24th. Almost a month past the date. You are dressed very nice for court. Thank you for wearing a shirt and a tie. You look fantastic.
Thank you.
Why don't we have anything charged? Almost 1 month to the day or two later.
Because one of the charges lacks probable cause in the police reports.
Then don't charge that charge, but he should be charged by now.
No, because I've asked for police follow-up to find the probable cause for that count.
I thought you started
Multiple
something in Polk County where
requests.
the day that they're arrested, they get probable cause, they get their initial appearance, they have a complaint filed. This should happen here too, because it's almost 1 month since this man was arrested, put on bail with significant cash of $1,000 with bail condition. If there's one count that is not yet enough for probable cause, then you can ask to amend the court. You know the statute, you know the rules. But now we have a man here who he's been under a bail bond condition for almost 1 month with $1,000 cash, and we don't know if there's enough to charge. There's enough at least for probable cause for some of these. You can amend later. You can even amend an information upon preliminary hearing. Right now, this is ridiculous that it's almost 1 month since his arrest, since he was put on cash bail, that he has not been charged.
Judge, we wait for complete reports before filing complaints because our policy is that cases are provable and triable the day we charge them. It's not right now. That is my office's policy.
You can't though,
If
you
the
can't
court-
prove and charge any of these, so you don't want to file anything because again, discussions of the fact that when you worked at Polk, you developed this system and it's to have all of these things. I don't know if you did that or who did this, but when a man's arrested or a woman's arrested in a lot of counties in the state and per the statute, they are to be immediately provided their criminal complaint. Is it directory? Is it mandatory? Who knows? But in a lot of counties, it happens the day of arrest. And there are amendments to the criminal complaint or amendments to the information. But now it is June 24th. And again, this man was arrested on May 22nd. He was arrested. May 22nd, he was arrested. But the court did place bond and cash on him on May 26th.
Correct. If the court conducted a bond hearing within 72 hours of arrest, I could have told the court of this, but our county doesn't do that.
Our county should do that. Our county should do that because I guess I'll pull up the statute right now. Because people's rights are restricted. That's why most, or a lot of counties, I can't say most, because we're one of the little counties that apparently don't want to do that. I'm sure you know the statute and you can probably pull it up a lot faster than I can, since that is your job every day. The state must file a complaint without unnecessary delay following arrest, which generally can be interpreted as 48 hours. 48 hours. And that's not just for the court to determine bail, but it should be filed. It should be filed with unnecessary delay. And to this court, this has been beyond an unnecessary delay. When a person is arrested without a warrant and brought before a court, before a judge, a complaint shall be filed forthwith. Forthwith.
This person was never brought before a judge. Bond was set in his absence.
The probable cause was brought before the court with enough information for the court to determine probable cause. So if we're going to start having people arrested and they're going to be brought before the court, then forthwith a complaint will be filed and we will start having bond hearings every single time a person is arrested. This is outrageous. It is completely outrageous.
I would approve of that process. That's why Captain Taggart asked the court to.
Oh, good. Then we're going to start doing that now. And so we will have a complaint filed forthwith at the bail hearing, correct?
We will not.
Then we will not arrest people. Then they will be not arrested and we will not see them, because bail should not be placed on a person unless a person is arrested without a warrant and brought before a judge, which they will be. A complaint shall be filed forthwith. And if other counties, including Polk County, can file it and get it done the day of the arrest, within hours of an arrest, I think Burnett County can do that too.
We will file it forthwith after those bond hearings if the court starts bond hearings.
All right, then I'll do that and we'll have the bond hearing and then the very next day we'll have the initial appearance. That was forthwith for the court. So is that what we're going to do, Mr. Schmidt?
I'd have to confer with law enforcement because they have not been consulted with this yet and not been given an opportunity to prepare.
There's enough. Do you understand what the PC comments or complaints that are filed, the probable cause complaints? They have a lot of information. They are puked with a whole lot of information. The officers do such a fantastic job for the most part in those probable cause statements. Enough where a complaint can be filed. Enough. I can even read this complaint that was filed by the Siren Police Department. There is enough there, right there, enough there that a complaint can be filed. That is forthwith. And all you do is cut and paste and put their complaint into the complaint, or their police reports into the complaints anyway.
Judge, the probable cause statement, you may have noticed, does not state when the drinking occurred in regards to when the crash happened. Does not state when the moment of driving was. It does not state whether an officer was actually spat on or not. And it does not say whether anyone was injured in the crash.
Well, then that is a Siren Police Department issue that you can talk with Siren Police Department. But I'm going to tell you, our county boys and girls and women and everybody, all of our county people, our county officers and deputies, they put a lot into their probable cause, a lot.
They do.
And so then I guess with Siren Police Department people, if that's what you're saying is the issue here, then perhaps they need to be trained on how to put in all of the information in a probable cause. So we can forthwith have charges.
And again, I don't charge based on probable cause. I charge based upon beyond a reasonable doubt.
Then
Charging
we
based on
cannot
probable
have
cause.
bail. Then we cannot have bail or bond conditions. So people need to be let out immediately, forthwith.
We can have bail conditions set based upon probable cause statements, and the complaints can be filed forthwith. We have the capacity to do that so long as law enforcement knows and they can prepare for it.
All right, forthwith, within 48 hours, I will do bail. Within 48 hours, we will have the initial appearances in every single arrest, every single that comes in front of this court for bail and bond.
Okay. I will speak with law enforcement of what the court's command is. I am going to be gone for the next 2 weeks, so there will be that problem.
Because to me, forthwith does not mean 1 month and 2 days after an arrest. That is not forthwith.
It does not. If there was a bond hearing, I would have told the court to do a signature bond for these reasons.
I would not do any bond, zero bond, none bond, because unless it's forthwith within 48 hours, nobody should have their due process rights taken away because we can't get a criminal complaint filed forthwith.
I agree. It is unreasonable for people to be on a cash bond without seeing a court and no.
Any
complaint.
bail bond conditions, any, because right now, this individual, if I have him on bail bond conditions, this individual, and he's not getting a complaint filed a month and 2 days after, why should he risk to have bail bond jump violations when he hasn't even been charged? He doesn't even know if he is going to be charged.
I agree.
So zero bail, zero bond, unless we have a criminal complaint filed forthwith within 48 hours.
I agree.
Done. Then that's what we're going to do. So, Mr. Campo, I'm not sure if you are supposed to have a complaint filed today. I'm hearing no.
Okay,
So you are forthwith discharged from all bail bond conditions. Forthwith, now,
really?
immediately. Cash will be returned to you. And bond, gonzo.
Amazing.
Okay? Thank you.
Thank you.
Mr. Linder. We will go on the record in the matter 26 TR 12, 26 TR 13, County of Burnett versus Jason Linder. The state appears through Assistant District Attorney Jose Vila in person. Mr. Linder appears in person without counsel. We're set here today in 2 ticket matters: operating a motor vehicle without insurance and non-registration of a vehicle automobile greater than 10,000 pounds. Mr. Linder, this is a status conference. What have you been doing? Have you registered your vehicle? Do you have insurance?
It's actually not even my vehicle. It's the vehicle I've been working on. I had just done a subframe swap on it and I was doing a test drive just to see if it's still driving straight. When the officer pulled me over, I've been trying to get a hold of the person that owns it. She doesn't have any money to even pay for the repairs, let alone get it registered. She's trying to sell the vehicle actually to try and pay for
Somebody owns
everything.
it.
So
Your Honor, if I may, we did give Mr. Lindner a letter saying that if he does not own the vehicle, we simply need something from the actual registered owner to say that she owns the vehicle and we will dismiss this.
Even just a letter because from the registered owner, it could, because it doesn't sound like the individual that
From the registered owner.
owns the car. She's going to need, somebody needs, whoever, it's been registered, it's been owned by somebody
Okay,
in the state of Wisconsin and or Minnesota and or someplace. So you need to get a hold of whoever you say owns it. They need to get a hold of the person who's the registered owner on the vehicle. And they need to get proof to the state and a letter stating that it is their vehicle, not your vehicle. But I don't know what happens if the person has passed away or if it's an estate vehicle or what not. You have to take care of it because otherwise you have these 2 tickets.
okay. I never received that letter that I guess.
If you could go down to the district attorney's office and speak to Laura Christensen, she'll get you a copy of it so you can take it with you.
Okay, that would be great.
A letter was sent, oh, just a letter between the 2, not.
Yes,
in the
Your Honor.
file. So go get that letter, figure out what you need to do, but you're gonna need to do it here soon.
Okay. I'll be on it right away today, so.
I need to get a next hearing date. I can give you a little bit of time to be able to do that. August 5th at 9:30, August 5th at 9:30. You can come back here and you will update the court. If you've taken care of everything and given it to the state, you won't need to come back. They'll just dismiss the matters, okay?
Okay.
You can come get your notice and you're free to leave. Mr. Martini. We will go on the record in the matter 26 FO 137, State of Wisconsin versus Keith Martini. The state appears through Assistant District Attorney Jose Vila in person. Mr. Martini appears in person without counsel. We're set here today in this matter for a status conference. This is a disorderly conduct matter. Mr. Martini, have you discussed this case with the district, with the state, the district attorney's office?
No, I haven't.
Mr. Vila, was a letter sent?
Yes, Your Honor, a letter was sent and we received a letter from Mr. Martini's wife that they, I guess, our previous meeting didn't go through because she had a chemotherapy session that impacted their ability to take that anger management course with Mr. Dave Hatch. Upon successful completion, I will dismiss the forfeiture ticket in its entirety.
Excellent. All right. So Mr. Martini, you're going to take that class. Is that correct?
That's correct, Your Honor.
I will give you this form. It is not court ordered, so I will not fill out this form. It's your responsibility to do the class and to contact Mr. Hatch and to make sure that he contacts the DA and the court when you complete it. Because if you complete it timely and we get proof by that, by the next court date, you will not need to come to that court date. Okay, and this takes 4 weeks to complete and it costs $150. Okay, I have circled his contact information, and if you set up a meeting with him and you do not show, you will be assessed $25 for each no-show, which you will need to pay, or you don't, I'll issue a warrant and you have to come back and tell me why you haven't paid it, okay? But I trust that you're gonna go to every one of these that you schedule. So there's the form. You can stay up here while you wait, because I'm gonna get you another court date, gonna give you plenty of time to be able to get that done, okay? You can stay because you're gonna need to get another notice. Oh, boy. Is August 26th time block? It's on the Schmidt week, but I'm gonna have to do that. We can do, let's do 9:30 on August 26th, 9:30, August 26th. So if you have everything done and you have it all completed, Mr. Hatch will send information to the state and to the county that you've completed it, then you will not need to come to this next date, okay? So this is 2 months out, should give you plenty of time, all right?
All right.
All right, thank you.
Thank you, Your Honor.
Thank you, we are adjourned. Didn't realize that you represent Miss Nutt and that she may not appear, she may appear through you. I was waiting for the 10 o'clock. All right, we will go on the record in the matters 26 TR 203, 204, 205, and 206. State of Wisconsin versus Tiffany Nutt. The state appears through Assistant District Attorney Jose Vila in person. Adam Benson appears by video conferencing. His client appears through counsel. We're set today in these matters for status conferences. Mr. Benson, please update the court.
We have received an offer, Your Honor. My client is uncertain yet if we could have one more date, and that date might turn into a plea. So
You have not received an offer?
I have received an offer. My
Oh.
client's still deciding. So
Okay. Okay, just give me a second. I can do July 23rd at 3.
works, Your Honor. Thank you.
All right, thank you. July 23rd at 3 p.m. Thank you, Mr. Benson. And now I guess we'll just wait until Mr. Anderson appears, and then we're ready to go with the Bellinger matter.
Your Honor, he said he might be running late. I spoke with him on the phone a little while ago. He was behind a slow pickup truck or something, he said. So he's on his way.
Okay,
All right.
that's
Thank
fine.
you.
I'll just put the court in the waiting room. We will go on the record in the matter 26 TR 181 and 301, Village of Siren, Town of Menon versus Robin Bellinger. The state appears through, or the village and town appear through attorney Adam Benson by video conferencing. We have Bruce Anderson appearing by in person with his client. We're set today for a status conference. Mr. Anderson, can you please update the court?
Actually, Judge, I believe one of these cases, the more recent one, is 2026 TR 301. That's actually up for intake today. I did file written not guilty pleas just yesterday, but that's an intake one. The other one's up for status. I have discussed the matter with Mr. Benson. Mr. Benson feels he may have a conflict and is let him speak to what his intentions are. I believe he may have to withdraw.
Mr. Benson.
Yeah, a couple of things, Your Honor. Both tickets should be Town of Menon, I believe. And then I had a conflict of interest come up with a defendant recently, and I would need to recuse myself, and I will reach out to Chelsea Whitley, as she's been taking on cases I have conflicts with.
All right, so is she going to take all 3 of these then?
I would ask her to, yes. So
Okay,
No, I'm confused. I thought there were only 2.
so
well,
did I.
wait, I have 18, no, there are 181 and I opened one of them twice. So it's 301 and 181. So she's gonna take both of these. Let me see when she is expected to be back. I don't have any court dates with her necessarily scheduled right now. So why don't I schedule it for something that works with Mr. Anderson, and then we can go from there. I have you coming back, Mr. Anderson, July 16 at 9. maybe that will work. And if it doesn't work with Miss Whitley, then she'll let Mary know and we'll reach out for a different date and time. Oh, wait, is that on? What is that on? Oh, did I schedule that? I must have. Yes, and that should be fine because then I have a meeting, a 2-day thing after that, but it's local, so.
Yeah, I can make 9 AM on that Thursday, July 16. Yes.
All right, July 16 at 9.
Yeah, I have a rough day here.
All right, thank you, Mr. Benson and Mr.
I have
Anderson.
one
We'll
more,
see you
do I
then.
not? Does
Oh, you
Mr.
do.
Youngren? Yes.
I don't know if Mr. Youngren,
Robin, I have your notice
Nope.
here.
not here.
Well,
So I don't know if you want to, I do have an attorney, so just
yeah,
wait.
Attorney Simon and I spoke
Yes.
earlier this week.
You guys are free to go. We will go on the record in the matter 26 TR 174, State of Wisconsin versus Andrew Youngren. The state appears through not the state, it's the Village of Siren versus Andrew Youngren. The village appears through Adam Benson, counsel. Mr. Youngren appears through his counsel, Attorney Brett Simon. We're set today for a status conference. Mr. Simon, please update the court.
Yes, Judge. I had an opportunity to speak with the village, I should say, prior to today's court date. They want an opportunity. I don't want to speak for them, but I believe they want an opportunity to speak with their arresting officer before we can work out some sort of plea agreement for your honor's consideration. I'd ask for a pretrial conference date, maybe 30 to 45 days out. I'm hoping we can have this one wrapped up by that time.
July 23rd at 3 p.m.
That would
Does
work
that
just
work?
great. That would work
All
fine.
right,
Thank you,
July
Judge.
23rd, 3 p.m. We'll see you then. Okay, just so if everybody knows, if people are going to go fast, I'm now going to click to know to slow down, okay? A billion things open. There's only 4, 1, 2, 3, 4. We will go on the record in the matter 25 TR 775, 25 TR 1015, 26 TR 378, 26 TR and 378. I guess there's only 4. County of Burnett versus Mark Chanel. We're here today for a motion hearing for reconsideration and a refusal hearing. I have documents filed by Mr. Chanel. I have received and reviewed those documents. Have you reviewed those documents, Mr. Vila? You appear in person for the state. Mr. Chanel appears in person without counsel.
Is the court referencing the most recent filings that Mr. Chanel did on the 16th?
15th. I
Sorry,
have
the
them.
15th. Yes, correct. Yes, I have reviewed that, Mr.
All
Honor.
right, okay. Okay. Mr. Chanel, these are your motions. What are you looking at the court? What are you looking for from the court today?
Dismissal of Your Honor, of the refusal charge.
Okay. All right, and I'm going to have both parties begin with arguments, and then we'll get into testimony. But I'll start with you, Mr. Schnell. It's your motion that you filed, and you are asking the court to dismiss your refusal. And I'm not sure if you're just asking the court to dismiss your refusal based upon the filings, but the state has not made any filings. What essentially are you trying to prove here today?
That I did give the blood and they're using the blood, so isn't that part of I didn't refuse it? And
Actually, the law says that it is counted as a refusal if the officer has to read you the informing the consent verbatim to you and brings you to the medical facility to take your blood. That is a refusal.
and the 8 months later charge,
Okay, and then the fact that it was issued 8 months later,
and
because this was from September 8th, 2025. And then you were issued the refusal. I believe it was just recently issued. May 20th of 2026. That's the basis for your argument, correct?
and I was not given a second blood test and I requested it, not an option to call anyone or anything.
Again, we went over that. That I'm not reconsidering. The law doesn't state that you get a second blood test. The law says that you get a second chemical test, such as blood, urine.
Yeah, they didn't not
Or
give
not
me an
blood, I mean,
opportunity
not blood,
to,
not blood. I meant breath or urine.
yeah, they did not give me an opportunity when I requested it
You asked to
multiple
have
times.
a breath test.
Blood test from,
Again, not a second blood test. You don't get a second blood test.
you don't get a second blood test?
No. But I guess the state can go ahead and get that testimony out of the officer so you can understand it better. Mr. Vila?
Thank you, Your Honor. In regards to the motion to dismiss the refusal portion, I don't know what relief can be granted here. He cites no statutes, he cites no case law. I don't know what his actual argument is here. I don't know what relief can actually be granted. This is also a civil issue. This is also a civil issue, meaning as long as he gets his right to be heard, there's no due process violations here. So I don't know what really we're arguing.
Okay, well, essentially his argument is, as I understand it, is that the refusal came 8 months after, which is a significant and substantial amount of time. And the state has to prove that it has a reasonable basis in order to file it 8 months after that time. So I believe, if I'm understanding his argument correctly, that is what it is.
Again, the Court of Appeals is pretty clear on this. As long as he gets his opportunity to be heard on the refusal prior to the conviction, it stands.
Okay, what case are you referring to?
One moment, Your Honor.
Because if I was looking at State v. Peterson and State v. Polinsky,
If the court would give me an opportunity to look it up, I thought I wrote it down. I did not. I apologize.
and I understand that the statute it contemplates the immediate preparation and service of the refusal, and that it's not directed, it's directed.
State v.
Not mandatory. And
Sorry,
I'm
Your Honor.
speaking right
Yeah,
now.
my apologies.
And so long as he has received notice, which he has, and the opportunity to be heard, it can, but the state still has to have a reasonable basis for having the significant amount of time and the delay from the original arrest to the date of sending of filing and charging the refusal.
Yes, Your Honor. So the case I'm relying on is State v. Moline, 170, Wisconsin, 2D 531, pages 540 to 41. as well as State v. Nordness.
State v. Moline, what is the citation?
170 WIS 2D 531 at page 540 to 41.
Yes, that it's directory versus mandatory. It's not mandatory, it's directory. Yes, but then we're getting into the whole, again, you have to go into the reasonableness of the delay.
Yeah, Your Honor, we're only relying on the fact that his procedural rights are being protected here,
Okay, all right.
and that he's be giving notice and opportunity to be heard.
All right, call your first witness.
State calls Deputy Bailey Mangan.
Deputy Bailey Mangan, please come forward, raise your right hand, be sworn in, have a seat at the witness stand.
Do you swear that the testimony you are about to give in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
You may begin.
Can you please state and spell your name for the record?
Yes, my name is Bailey Mangan. My first name is spelled Bailey. My last name is spelled Mangen.
And how are you currently employed?
I'm currently employed at the Burnett County Sheriff's Office as a sheriff's deputy.
And how long have you been so employed?
I've been full-time with Burnett County Sheriff's Office since December of 2019.
So you were employed in that capacity on September 8th of 2025.
I was.
Did you receive any training prior to becoming a police officer?
Yes.
What was that training?
Prior to becoming a police officer in the state of Wisconsin, I attended a 720-hour academy through the Wisconsin Department of Justice. That was at Chippewa Valley Technical College. During that academy, you're certified in several different topics and subjects.
Did any of that training focus on the detection of alcohol?
Yes.
How long was that part of the course?
I don't recall the exact time frame of the OWI investigation or OWI portion of the academy, but it was spanned out over several days.
And what did that portion of the training look like?
That specific portion of the training included various in-class instruction as well as either 1 or 2 days of scenarios with actual alcohol dosed test subjects and test subjects, not role players.
So did you learn anything about the specific things to look for to determine if someone had been drinking?
Yes.
What kind of things indicate someone's consumed alcohol?
There's a numerous amount of things, both physical factors that may indicate somebody's under the influence of alcohol or other substances. Some of those things might include slurred speech, bloodshot or glossy eyes, the inability to have normal cognizant responses, the odor of alcohol coming from somebody, the inability of or the lack of balance or like fine motor skills might all be things that are indicative of somebody who's under the influence of a substance.
So turning your attention to September 8th, 2025, at approximately 1:55 a.m., where were you?
I was driving on State Highway 70.
What were you doing?
Just on normal patrol.
Did you see anything strange?
I did. I saw a vehicle that was parked or stopped on the side of the road, partially in the roadway on Wood Creek Road, on the south side of Wood Creek Road, on the south side of State Highway 70.
Okay, and Wood Creek Road, is that in Burnett County?
Yes.
And Wood Creek Road, is that a public highway?
Yes, it's a township road, but it's a public roadway.
Okay, so what'd you do after you noticed the vehicle?
If I remember correctly, I actually drove past Wood Creek Road. I noticed the vehicle, so I turned around and then came back and turned south on Wood Creek Road and pulled behind the vehicle that was stopped.
Did you approach the vehicle?
I did.
Now, on that day in question, September 8th, 2025, did you have body camera on your person?
I did.
Was it working that day?
It was.
Prior to today's hearing, have you reviewed your body camera and from the day in question?
I did.
If I showed it to you, would you recognize it?
Yes.
I'm going to play a video.
Uh, is this like a trial right now?
It's a hearing. It's the refusal hearing you requested.
It is usually you bring your videos in and your witnesses and stuff.
It is a hearing, yes.
I could bring witnesses in for the trial
For the trial, yes. This is
and for hearings.
yes, if you have a witness that was a part of this that would be applicable to a refusal hearing, yes.
How is the refusal hearing for the blood test this relevant?
This is different. This is,
Different.
Mr. Chanel, you were served that, you were served 26 TR 378, the refuse to take tests for intoxication after arrest. Although the offense date was September 8th, 2025, it was served on May 20th, 2026. Then you filed your request for a refusal hearing, what we're doing here today, on June 1st, 2026, within that 10-day time frame that the statute indicates. All right. And so we are here for that refusal hearing that you requested. Remember back at another hearing, you said, well, I filed the thing with the DMV, okay, the Department of Motor Vehicles. I filed that, so you should have that. I don't have that because you filed whatever you did with the DMV. Now, you were charged again on May 20th, 2026 with the refusal to take the test, all right? And then on June 1st, again, you requested a refusal hearing. You said, I am requesting an administrative hearing on the notice of intent to revoke my operating privilege dated May 20th, 2026. I timely submit this request within the 10-day period. So you're getting the refusal hearing. That's what
All
we're
right, I
doing
didn't
today.
see how this was relevant to the refusal.
It's all relevant
Okay.
to the
Okay.
refusal. So if that's an objection, it's sustained.
Your Honor, we'll be playing Deputy Bailey Mangan's body cam.
So you'd like me to set up
Yes, please.
the equipment?
And there's no prior video other than this. I'm just,
Mr. Chanel, the state can use any segment of the video that it wishes to present if it's relevant to the hearing that we're here for.
yeah, I was asking.
Yes.
There's no other video prior to this.
I'm not certain. That's a question for the officer that you can ask him when you ask him questions.
Okay, thank you.
Okay, because I'm brand new to this, like you, except I wasn't at the incident. This is my first time to get any of the information concerning this matter,
Right.
okay?
Do you recognize this video?
Yes, I do.
Would you say it's a fair and accurate description of your interaction that day of September 8th, 2025?
I would.
All right, I'm going to start playing from 0 seconds. 1 moment.
How's it going? How's it going?
Yeah, how about you?
Good. I'm just stopping to check on you. Is there a reason why you're stopped on the side of the road?
Yeah, my brakes are loud.
Your brakes are what?
Loud.
Are loud?
If I got me.
Your brakes are loud?
Yep.
Is that why you're stopped though?
Yeah.
Okay. Where are you headed?
3 miles up that way and 2 miles over.
3 miles up that way and 2 miles over?
Yep.
Okay. Do you have your driver's license on you quick? Can I take a look at that? Were you peeing or something, or what's on the road here?
Yeah, that's
Oh, okay.
that. What is the regulation?
What's that?
I'm just thinking the regulation for that.
For peeing on the road?
Yeah.
Well, it's not necessarily ideal, but do you have your license I can take a look at?
Yep. Trying to put the brakes in this. I had to open the door and find it. I think it's that.
Okay. What's your name?
Mark.
Mark what?
Chanel.
Mark Chanel? Where are you coming from, Mark?
The passage at 11 o'clock.
You worked that passage at 11?
Yeah.
Where are you coming from now?
Then I went to Pheasant and I'm coming home. I'm not trying to move.
You're good. I can just grab your information.
No, I'm sorry.
So it's Michael, M-I-C-H.
No, Mark.
Mark, sorry, I apologize. Mark or Marcus? Mark Chanel. And what's your date of birth, Mark?
I'm 05-1888.
05.
1888. You're recording, all right?
Yep.
Okay.
What's your middle name, Mark?
David.
All right, sounds good. Sit tight, I'll be right back for you, okay?
Oh.
And I'm pausing at the 2 minute and 35-second mark of that video.
Thank you.
Deputy Mangan, do you see that same Mark Chanel in the video sitting here in the courtroom today?
I do.
Could you please identify him?
He is seated at the defense table wearing a blue Nike polo.
The record reflect Deputy Mangan has identified Mr. Chanel.
Now, while speaking with Mr. Chanel, did you make any observations?
Yes.
What were those observations?
I made several observations during my initial contact with Mr. Chanel. Those observations included slurred speech to the point where it was at times difficult to understand what Mr. Chanel was saying. He had an extreme lack of enunciation to all of his words amongst the slurred speech. I noticed an odor of intoxicants coming from his person while he was sitting inside of the vehicle.
Are these indicators that someone's been drinking based off of your training and experience?
Yes, all of those things are indicators that somebody might have consumed or has consumed intoxicants.
I am fast forwarding to the 4 minute and 39-second mark.
439, thank you.
Mark, do you want to jump out, come back here and talk to me for a second,
Yep.
please? Thank you.
I do have a latch that.
I see that. So how much have you had to drink?
I have work at 11, so what time? Can I look at my phone?
I can tell you it's 2 o'clock.
3 hours?
Okay. How much have you had to drink tonight?
Oh, a few beers with friends.
A few beers with friends. How many is a few?
I don't remember.
If you had to guess.
I don't remember, but you can do it.
What kind of beer were you drinking?
I don't remember.
Okay.
But No, my brake is bad. I have brake pads now.
Yeah, I see that. Have you had anything to drink since you left the bar?
I left work 11.
Yep.
No, that's all.
So then you went to the Pheasant Inn,
Yep.
and then did you leave the Pheasant Inn and come straight here?
Yep.
How long you been parked here?
No, not 2 minutes.
2 minutes? Okay. And you haven't had any of your drinks
I
then?
was just, yes, no, I had not. No.
Okay.
Yeah.
All right. Sounds good. Let's walk
No.
back by my car here quick.
Yep.
Are you willing to do some field sobriety tests for me to make sure you're safe to be driving?
Yeah.
Okay.
Deputy Mangan, are you trained in conducting field sobriety tests?
I am.
Were you certified to conduct those standard field sobriety tests on the date in question?
Yes.
All right.
Sir.
I know. All right. So what I'm going to do is I'm going to have you.
What are standard field sobriety tests used for?
Standardized field sobriety tests are used to determine somebody's level of impairment.
Stand just like that, okay? Those lights too bright in your eye when you're looking at me right here, or no?
I'm fine.
They're okay right there? Okay. So for
I'm sorry. I was thinking about my friends getting home.
the first thing I'm gonna do is I'm gonna check your eyes, okay? Anything wrong with your eyes? I see you're wearing glasses. Do you need your glasses to drive?
Yeah.
Okay. All right.
Technically, yes.
Technically, yes. Okay.
So, yeah, I'm always honest.
What's that?
I'm always honest.
I appreciate that. Do you have anything, Yeah, you're good. You can put that back in your pocket for now. You're good. I can see
hope
it.
my wallet's small.
Okay. Yeah, and we'll look for that in a minute here. So 10-2. Yeah, you can face that way. That's fine. The first thing I'm gonna do is I'm gonna check your eyes, okay? For this test, I want you to take your hands out of your pockets, put your arms straight down at your side. Okay, put your feet together, stand just like that, don't move at all, okay? You understand? You understand?
Yes.
Okay. The goal for me with this flashlight is to be able to see your eyes. I don't want to shine it in your eyes, but I do want to be able to see your eyes, okay? So what I'm going to have you do is I'm going to have you tip your glasses up, put them on top of your head for me, okay? Put your arms back down at your side. Can you see the tip of my finger here?
Yes.
Okay. What I want you to do is I want you to follow the tip of my finger with your eyes and your eyes only without moving your head. Do you understand?
Yes.
Okay.
I don't think your video recording is good.
What's that?
I don't think your video recording was
On right now.
Oh, awesome.
Yep. It's been on the whole time, okay?
Yep. Thank you. No, I love police officers. Love the jobs you're doing. Cool. I'll look straight.
Nope. I need you to follow the tip of my finger with your
Yep,
eyes and your
yep,
eyes.
I'll
without
give
moving
it
your head. Okay? You look at my finger over here.
Mhm.
You just follow the tip of my finger with your eyes and your eyes only, okay?
Yep. That's so good.
Okay. You doing okay?
Yeah, I'm good.
Okay. All right. So the next.
I'm going to stop you right here before you ask questions because I forgot to do what I normally do before we start these types of hearings. Mr. Chanel, this is a refusal hearing, and in the beginning you were having a little, you didn't understand what we were doing or that we were having the hearing that we were having here today. So now do you have a full comprehension of what we're doing here today with the refusal hearing?
Yeah, I thought it was during the trial we do this.
No, because
That's what I wasn't prepared. That was my understanding.
No, because you asked for that refusal hearing. And the refusal hearing is where the court has to determine whether or not you refused to consent to the blood request that the law enforcement asked of you. all
Wouldn't
right?
that be at the hospital
Or,
video
or
footage?
actually, yep, the breath, okay, blood, breath, urine, those types of things. And you refuse to comply with the officer's requests. And that's why we're having this hearing. And you were very prepared. You had information as it relates to refusal hearings in the motions that you filed. So I'm not sure if right now the court doesn't necessarily have a local rule for AI, but we're getting one here very soon. And I'm not sure if you used AI in your preparation or in your filings, or if you did your own legal research. I'm not sure if you did the legal research as it relates to refusals and refusal hearings. And before we continue and go down this road, I want to make sure that you understand what could happen at the refusal hearing. If at this hearing, the court finds that you did not lawfully refuse, you didn't have a legal right to refuse the requests of the officers. If that's what I find here today, I must, I shall, I have to, the law says, immediately revoke your driver's license for 1 year and require for 1 year an ignition interlock device to be placed upon your car. And that's if I find that your refusal was not lawful. All right. So do you understand that?
Can I request to prepare more?
No, because this is why we're here and we have the trial that's coming up.
Well, I was not understanding that that was the case at this moment.
And again, you should have, because you're representing yourself, and the court did provide you with the opportunity to have a free consultation with Bruce Anderson, who is a very renowned and experienced OWI, operating while intoxicated attorney. All right. So you were permitted to do that. And because you're representing yourself and that's what you wish to do, and you wanted to do that from the beginning, even after speaking with Mr. Anderson, it is your job and your duty to come prepared for the hearings. So that's why we're here today. All right. So here's the refusal hearing. And if at the end of this hearing, the court finds that you unlawfully refused, then that means I shall, as of today, revoke your driver's license today for 1 year and require that ignition interlock device for 1 year. All right. So do you understand that? Do you understand that?
Yes.
Okay. And Mr. Vila, I forgot to go over these things and I forgot to ask again for you to recite the offer that was presented to Mr. Chanel.
Yes, Your Honor. So the offer still stands for him to plead to the OWI first using those .099 guidelines, meaning the 6-month revocation of the license, no requirement of the ignition interlock device. I believe he already did his 6-month administrative period, so that's already been served.
All right. And so it would be for the mandatory minimums for an OWI first. Is that what I'm hearing?
Correct, Your Honor, and we would not pursue the refusal.
And so you would dismiss the refusal hearing and you would dismiss the second ticket that was written, the operating with a PAC greater than 0.15. Is that correct?
That is correct, Your Honor.
So Mr. Chanel, I want you to fully understand here today that what the state's offer is to plead to the OWI first with the lowest minimum guidelines. Okay, just wait, the lowest minimum guidelines. Because right now your blood alcohol content, which I don't have the lab analyst here to testify, but what I am understanding it was over 0.15. I don't have the exact amount. I think it was 0.2, if I'm recalling correctly. 0.2 is what as far as I know, it came back as a 0.2, the allegations as alleged by the state. The state is again offering to go far below the 0.15, and that's the minimum, the minimums in Wisconsin for the OWI, okay? So that would be the 0.09, and to ask for the minimum revocation of 6 months of your driver's license, but to give you credit for the 6 months because you've already had it administratively suspended. So that means you would have already complied because it's been that long. And they would not require or ask the court to order an ignition interlock device. All right. And so you can understand that if this matter does move forward again with the refusal today, and the court finds you unlawfully refused, I shall, as of today, revoke you for 1 year, no administrative credit, and having 1 year of ignition interlock device. And if this matter proceeds to a jury trial on the OWI first charge, and you're found guilty of the OWI first charge, it would be for the 0.2, not the 0.09 that is being offered by the state here today. So higher fines, higher revocation of driver's license, higher ignition interlock device requirements, those types of things. So do you understand the offer that the state is presenting you today?
Yeah, could I take a few, like 5 minutes to think about it?
I can give you 10 minutes if you want to think about it.
I just have to consider 5 years of not driving for my job.
Yep, I want you to, well, here's the thing, again, the offer is 6 months of revocation of your driver's license with the credit that you've already sat. And to get an occupational, you would have to do an OWI AODA assessment, like with Aurora, and the driver safety plan, and then you can get an occupational as soon as you get those things complete, I believe. Because you've already sat.
Would I even need to do that in July 12th after 6 months?
You would not know.
So if I just kept riding with people and paying them?
After 6 months?
Yeah, it's like after July 15th.
After July 15th, if you've done the OWI assessment and the driver safety plan, which is a legal requirement of the state, then your period of the 6 months would have lapsed and you could go to, I don't even think you'd need an occupational. You can just get your driver's license reinstated.
I'm just considering the 5 years of my job not being able to drive for, so.
Why wouldn't you be able to drive for 5 years?
It's just like company policy.
As a Northwest Passage policy? Well, what I can do is we can take a little break if the state's okay with that.
Yes, Your Honor. I just would like to mark for the record that I'm paused at 9 minutes and 16 seconds.
9 minutes and, are we proceeding with the hearing, Mr. Chanel?
I have a question. If at trial I'm not guilty, if I'm found not guilty at trial, would the refusal be dismissed as well?
No, today is when you determine if you're guilty or not guilty. Today is that day.
So you don't get a jury for this?
You do not get a jury for your refusal.
So even if I'm not guilty, if I was during the trial, I was not guilty, I'm just asking under the Fourth Amendment.
Let's just think about that. No, because you can be guilty of refusing even if you're not guilty of an OWI per se. Mr. Vila?
Yeah, so it's an administrative process what's happening today. So this is completely separate from the OWI that's going to be tried at jury trial. And since these are civil matters, there's no Fifth Amendment right that gets invoked here.
So it's two different charges?
It's essentially.
So I can get charged with the OWI and the refusal for the same case?
Correct, yes. Same thing, same case, but today is the day to determine the refusal. And I get to determine that by all of the evidence that I see in the video and by the testimony of Deputy Mangan and by your testimony, if you wish to provide testimony here today. You don't have to, but you can. So that's today is refusal. They're two separate things. So even you can be found guilty of an unlawful refusal and still be found not guilty of an OWI for one reason or another at a jury trial.
So if like the Fourth Amendment, if that was the case for this, if it was found that way, would that remove the refusal?
It will not remove the refusal, no.
It wouldn't suppress the refusal or whatnot?
No.
No. Okay.
So do you want more time to think today? Do you need, because we still have 3 minutes.
For this, so the max cost would be $968.
Not the max cost here
We gave him an offer from when this case first initiated, so that's the number that he has, Your Honor.
Oh, I have 936.50 for
Okay,
the guidelines.
so even cheaper then.
Yeah, my District 10 guidelines for below 0.099 is $936.50.
And there's no hidden fees or?
There's, and a $10 blood draw fee,
Oh, okay,
but that's it.
Nothing like,
Nothing else, no
crazy,
more than
like-
that. That's it. So here's what I can do. If you want me to give you what the maximum possible penalty would be for the offer that's been provided versus if you're found guilty of the OWI second, I can do that. I can't go much further because you're asking questions and you're asking the court and or the state to provide you legal advice. Okay, and I can't do that. I can answer what the law is, but I can't say, Mr. Schnell, you really need to think about this or think about that. That's for you to determine, or you and an attorney if you wish to do that. But with the offer that's presented by the state with the below 0.099, the maximum penalty would be a fine of $936.50 plus a $10 blood draw fee, 6-month revocation of your driver's license, and no ignition interlock device. But you do have to do that OWI AODA assessment and the follow through.
does that cost money?
It does cost money. But here's what the court's always willing to give leeway and help with the fines and fees, and you can be on a payment plan. So you don't have to come up with the money right away. With the assessment, you would, and that's $285 or $287. That has to be prepaid to Aurora, right up there by the DMV. So if you have questions about your driver's license, go to the DMV and you can talk to Aurora, one fell swoop.
How soon is that? Like you can schedule that?
As soon as they have openings, but you have to pay for it first
Yeah.
before they will schedule that for you. But it's as soon as they have openings. However, if you are found guilty today of an unlawful refusal, that would be from today, a 1-year revocation of your driver's license and an ignition interlock device for 1 year,
No matter
court
what.
costs and fees. What?
No matter what?
No matter what.
No matter
If you're
what?
found guilty of an unlawful refusal today.
Okay, and there's no way to do that other than what's it? When you get the case tried,
Again, they're two separate things.
no, I know, but there's no other way than, hold on, I'm trying to think of the word. Would say you're found not guilty or guilty, guilty, what do you do? What's the next step called? I'm trying to remember.
An
Sorry.
appeal?
Appeal. Can you get the appeal for the refusal?
Yes, you can. You can appeal the refusal. You can appeal an OWI conviction. You have the right to seek an appeal with the Court of Appeals. That does cost extra money, and you do have to pay for transcripts and things, so that's extra money too, but you would have to talk to our court reporter and she can figure out and give you an estimate of how much that would cost. But yes, you do have the right to appeal.
I'm just considering the 5 years still.
If you were to be found guilty of an unlawful refusal, again, today, it would be 1 year revocation, 1 year ignition interlock device from today, plus court costs and fees. And if later you're found guilty of the OWI first with the blood alcohol content of 0.2 or more, it would be $1,081, 7 months revocation, plus a $10 blood draw fee, plus the ignition interlock device for 7 months to a year, or 7 months to a year.
Yeah.
Do you need another 5 or 10 minutes?
Yeah, I'm just thinking, sorry.
We can continue with the hearing.
Yeah, we can continue with the hearing for now.
Excuse me?
Yeah, we can continue with the hearing for now.
Well, I need to know if you're accepting or rejecting the offer, because if you're accepting the offer, we do not need to continue with the hearing. But if you are accepting the offer, then if you're accepting the offer, we don't need to continue with the hearing. But if you're rejecting the offer, we will continue with the hearing and I will make a decision.
And there's no way to change that.
There's no way to
from-
change
Other
that.
than appealing.
Correct.
All right, I guess I'll just do this.
You want to plead guilty to the OWI first?
Yeah. Is there a trial we can do to do that or just a,
Nope, today
That's
it's just fine. Like if you wish to accept the state's offer, which has been presented, you can do that today, lickety split. And then you would have the right to continue to appeal it. If that's what you wish to do.
okay. No, not if I plead not guilty, let's plead guilty.
Oh, if you plead guilty, you still can appeal it if you plead guilty.
You can appeal what?
I can't give you legal advice. I can tell you with every conviction, the court does state that you have the ability to appeal. But you can speak to an attorney about
All
that.
right, thanks. I'll do it this way, I guess. I will, as long as it's stated right here, I will do the 6 months one, the plea offer.
You want to accept the plea offer from the state.
Yes.
All right. Again, for the record, Mr. Vila, please recite the offer.
Yes, Your Honor. The offer is to plead to the .099 guidelines for the OWI first, and we would stipulate to the refusal being lawful. So it'd be what he has in front of him.
Okay. And so you wish,
What was that second part?
It means we won't pursue the refusal today, which is that higher penalty.
so you won't get punished today. I won't find you unlawfully refused. You won't have a 1-year revocation of your driver's license and 1 year of ignition interlock device from an unlawful refusal date.
All right.
You
Okay,
wish to accept the offer?
yes.
Okay. Formal motion to amend the blood alcohol content from 0.20 down to less than 0.099.
So made.
Granted. How do you wish to plead? I'll allow you to plead guilty or no contest. No contest means you're saying, you know what? I'm saying that they could prove this. I'm not going to say I did it. I'm not going to say I didn't do it, but I'm willing to
I
accept the
plead no
responsibility.
contest.
Want to plead no contest?
Yes.
Okay, no contest will be entered on your behalf here today. I will assess $936.50, $10 blood draw fee, 6-month revocation of your driver's license with credit for any administrative suspension you've already received, OWI assessment, OWI AODA assessment, and the driver safety plan and follow through. I can give you a payment plan if you wish to have a payment plan. $150 a month. Does that sound doable in your budget?
I have a credit card, I can pay it.
You can pay it all off today?
I'll
All right,
throw
well
in the
then
credit
that's good
card.
because otherwise the court could issue a warrant if you fail to pay or fail to pay your monthly, and you could sit up to 6 months in jail. So you're gonna pay that off here today. You would need to look into your ability to appeal and the timelines and all of that, if that's what you wish to do here today or after today. The court will find the refusal based upon the agreement between the parties is lawful and will dismiss the refusal charge. The court will dismiss and merge in 25 TR 1015, the operating with a PAC, prohibited alcohol concentration greater than 0.15 first offense. You understood, Mr. Chanel, that you had the right to go to a jury trial of 6 of your peers, and that 5 out of the 6 would need to find by clear, convincing, and satisfactory evidence finding of guilt or of a not guilty?
Yes.
Okay. And you've had plenty of opportunity to speak with an attorney, including attorney Bruce Anderson, who has been a practicing attorney for 35 or so years with OWIs.
Yeah, I talked to him briefly.
Okay, and he did indicate as he was leaving at the last hearing that you would be able to call him if you wish to later. And so from the last hearing time that we had on May 28th to 2026, did you get in contact with Mr. Anderson after that?
No, because I didn't think I could afford him.
Well, I didn't know what he said. I didn't know if he gave you a price or anything like that. Okay, so anything else that the state would like to state on the record?
No, Your Honor, I think we covered it all.
Mr. Schnell, anything you would like to add and state on the record?
No. not
Okay.
this time.
All right, then we are adjourned. All other matters have been handled and taken care of. The jury trial is now.
Jennifer Ashby thought she was doing the right thing when she walked into court. She came prepared to make a payment on a traffic ticket and clear up a warrant she didn't even know existed. But within seconds, the judge realized something wasn't adding up. When the judge asked if she was the one driving the vehicle, Jennifer immediately said no. According to her, it was actually her roommate who had been driving. That's when the judge became completely confused. If you weren't driving the car, why would you come to court asking for a payment plan? The courtroom fell silent. The judge asked the same question again and again, trying to understand her logic. Jennifer explained that another officer had told her to come to court and take care of the matter, but the judge wasn't satisfied with that answer. He pointed out that innocent people don't normally show up ready to pay a ticket for something they didn't do. Then came the reality check. The judge explained that if Jennifer truly wasn't the driver, she shouldn't simply accept responsibility and start making payments. Instead, she needed to formally challenge the ticket and prove that someone else had used her name. The law has procedures for situations exactly like this. But the judge didn't stop there. He turned his attention to Jennifer's roommate, the person she claimed was actually driving. The judge warned that giving false information to police could create serious legal problems. Then he delivered a line that nobody in the courtroom expected. How can you be friends with somebody that just got you in trouble by giving false information to a police officer? Who needs enemies if you've got friends like that? In the end, the judge gave Jennifer instructions on how to fight the ticket properly and wished her luck. But the lesson was clear. Never accept blame for something you didn't do, and be careful who you trust, because one friend's mistake can quickly become your problem.